Live stream audio test 1 2.
So I think it's time to make a start. The inquiry is now open. I'm going to work on the assumption everybody can hear me and that proceedings are audible throughout unless people tell me otherwise. It seems to me that, well, I can hear myself back through the PA. Hopefully people can hear us online as well. If you do have any difficulties during proceedings, please don't suffer in silence. Just let us know. I'm sure something can be done about it. That stands for any day of the week and for everybody who's speaking, please. To help with that, a couple of things. Can you make sure that you use, if you do want to speak, make sure you use the this PA system here. We'll find out what the arrangements are tomorrow when we get to the venue. And the other thing is, if you can just double check your mobile devices are switched to silent, that would help things. There's always one, but don't let it be you. Okay, on that, I'm Gareth Jones. I'm a Chartered Town Planner. I'm also the Inspector appointed by the Secretary of State to hold the inquiry. The inquiry relates to two appeals. Both are made by the same appellant, Strongbox Homes Limited, and they're made under Section 78 of the Town and Country Planning Act 1990. I've been referring to them as Appeal A and Appeal B. I don't know whether that's caught on or not, really. Well, I'm getting nods from one side, but I'm going to proceed on that basis unless I'm not precious about it. If everybody's got a better understanding of them in other terms, let me know. But I'm going to proceed on that basis. So, Appeal A is an appeal against decision of North Somerset Council to refuse outline planning permission for access with all matters reserved for the erection of up to 61 dwellings, including 18 affordable units, that's at 30%, along with access from Butts Batch and the provision of play facilities and public open space stroke ecological mitigation land with associated works at land at Butts Batch. The second appeal, that's to say Appeal B, is in respect to the failure of the council to give notice of its decision that planning permission its failure to give notice of its decision in respect to the planning application within the prescribed period for the laying out of hard-standing and associated works to facilitate a new public right-of-way on land adjacent to Northwood Close, Wrington. Although they are different applications and different sites, quite distinct sites, they do abut with the appeal site being located immediately to the north of the appeal site, a site, I should say. One housekeeping point, I'm advised that there are no practices for emergency proceedings this week planned, so if the alarm does go off, it's the real thing. They do test the alarm here on Friday. We'll have to do all this again tomorrow when we're at a different venue, but if the alarm does go off, it will be the real thing. So I think the escape means are clearly indicated. There's one to my right, some people's left, and another one over to my left. No doubt people from the council will assist us if it does go off. In a moment, I'll take a note of all those people who wish to speak. And before I do, I'm not asking for answers immediately, but I'll just float these now and hope to be corrected if I've got them wrong. Sort of 3 bullet points on where I think we are with the parties' positions. So the first is in respect to Appeal A. My understanding is the council's no longer pursuing a case in respect to the effect of the proposed development on Wrington Conservation Area, and that was something that was expressly cited in one of the refusal reasons, but I think that has now gone away, and I'm going to continue to work on that basis unless somebody tells me otherwise. My second bullet point of the 3 regards Appeal B. The council has confirmed that it's not contesting this appeal. That's to say, Appeal B, the new right-of-way to the north, on the basis that it would have resolved to grant planning permission had it been in a position to do so, had the appeal not been lodged. And again, I think that's a matter of record now, but if I've got it wrong, please let me know. And then my third point is concerning the common ground that's been found between the applicant and the appellant regarding 5-year housing land supply. I don't think it's complete common ground, but there's a position for me to, I'm being invited to make my decision on, and I think that's 3.2 years. But again, if I've got that wrong, please let me know. Okay, I'll now take a note of the parties who wish to speak. Can we, starting with the appellant, please?
May it please you, said, am I capturing the microphone?
Well, I can hear you, but it might be because I can just hear you.
You're very close to me.
Indeed.
So, thank you. My name's Christopher Boyle, B-O-Y-L-E. So I'm of Queen's Counsel, and I'm instructed by Pegasus Planning. And so you'll have had a raft of proofs from the appellants. Not all of those now need to be spoken to as live witnesses, but they're all before you. In the indicated order of appearances, which we'll come back to, so if we may, they are as follows for the witnesses. Martin Lier on landscape. Then, I think so, you have Ben Stoodley down as my next witness on drainage concerning a third party point. Then Hannah Armstrong on heritage. Then Tony Jones on transport, again addressing third party issues. Then Chris Marsh on planning. And then in addition, those are the live witnesses. And then in addition to those, you will have had a proof from Mr. Tiley, Neil Tiley, on housing land supply, which for the reasons indicated, we don't think you will need to be troubled with. And Mr. Jim Phillips on ecology, which again was produced as a result of third-party objections which have now been withdrawn. So again, although you have it, you shouldn't be troubled with it.
Okay, thank you for that. I picked up some correspondence regarding your transport witness, Mr. Jones, who I hope it goes without saying isn't any relation, but it's probably worth saying. And his availability, is there an update on that without prying too much into his...
Do you want to deal with that now?
Please.
Yes, Mr. Jones, unlike many people, poor Mr. Jones has not only contracted COVID, but is actually suffering with it. So he is not able to appear this week, having tested positive. And in any event, he's actually unwell. Now, so he is hopeful, and we are hopeful, that by Tuesday of next week, which is when he was perhaps likely to be coming forward in any event, but certainly by Tuesday next week, he will be physically well enough to attend. He will certainly be out of his isolation period, although I think, in fact, the law's changed now. But in any event, he'll be a distance from his test, but he's hoping to be well enough. If he is not, we do have cover. It's obviously not as happy a situation because the author will be speaking to proof he didn't produce, but it is within his team, and we have highways evidence able to be led, therefore, if we delay it to next Tuesday. If we try and put him in this week, I think there's no prospect of having the witness. But if we delay highways to next week, then there is a real prospect of having Mr. Jones back, fighting fit, and that's when I'd call him. And then so I'd propose to call Mr. Marsh, the planning witness, after him in the usual way. So that has a consequence for the programming. It may be that Friday, therefore, becomes rather a short day, but we may be able to do other matters in that, I don't know.
Okay, that's helpful, and yes, it's unfortunate way of the world at the moment, but it sounds like something that can be accommodated if things go as anticipated, and it's good that we've got a contingency as well in terms of potentially an alternative witness. Not ideal, but it's good to have that contingency. Okay, for the council, then, please.
Sir, thank you. My name is Wadsley, spelled W-A-D-S-L-E-Y, Peter Wadsley. I'm counsel, and I'm instructed by Richard Kent, who's head of planning at North Somerset Council. And as I think has been indicated already, I shall be calling in this order Mr. John Etchells, who will deal with landscape, Dr. Kate Hudson-Macaulay, who will deal with heritage, and Mr. Mark Reynolds, who will deal with planning.
Okay, thank you for that.
Thank you, sir.
And now we come to the Rule 6 party, which is keep Wrington as Wrington. Who's representing them, please?
Good morning, sir. My name is Richard Storer.
Good morning.
I'm representing the local group as part of the group. I'm not council. I intend to call my witnesses Mr. Dorr, who will deal with landscape and heritage as combined effect together. Miss Big, who will be representing the CPRE. Miss Abdul Wahab, who will be dealing with the use of the proposed site regarding the agriculture and sustainability. Miss Marwood, who will be dealing with the footpaths and general access to that site, and Mrs. Edgar regarding the Appeal B.
Thank you for that. You feel a bit distant, but rest assured you're very visible and I can hear you loud and clear. Thank you. Is there anybody else who wishes to speak? I'm aware that there are, but I'm also aware that there's a likelihood that a lot of people want to, or most people want to speak tomorrow, but equally I don't want anybody here today who would like to speak today not being given that opportunity. So is there anybody who would like to speak present who would like to speak today? No hands going up. Okay, well I'll work on that basis, but if anybody does come in and if that message can be communicated, I'm perfectly happy to hear from people today if they're not able to be heard tomorrow. Okay, we'll deal with those parties tomorrow then, rather than explaining process and taking names now. On that basis, I should turn the page on my notes, and which brings me to a heading, filming stroke recording. Now, obviously, we're being, I think we're being live streamed. Have I got that right? So I'm looking at the council's side now. I think that's your practice. It all goes on YouTube.
That is the case, sir. Yes.
Okay. Well, we've all had our hair done, I'm sure, and looking the part. Well, hello to everybody out there on the internet. You're very welcome. I'm glad you've been able to join us. I think at the case management conference I mentioned that the planning inspectorate communications team might come along and film parts of the proceedings. They are conspicuous by their absence. They've decided that they're not going to do that now for reasons that aren't entirely clear to me, but no bad thing from my point of view, one less thing to worry about. If that was on your mind, no need for it to be anymore. They're not coming. If anybody intends to record proceedings in any way, above and beyond what the council are doing, please let me know, just really out of courtesy to other people, but I don't think there's any need, because the council record these things, and I think you keep them and they're just kept on the internet. Yeah, okay. In terms of the notification letters, yeah, I've been provided with copies of the council's letters of notification regarding the appeals and also the inquiry dates. Just a procedural point, really. I didn't notice anything untoward that caught my eye, but just to be belt and braces, can somebody from the council confirm that the relevant parties were notified of the inquiry and of the applications?
Yes, sir, that is so.
Yeah, that was a very firm nod. Okay, thank you for that. I'll come back to the site visit in a moment, but I had a look at the site and surroundings yesterday outside the inquiry process, and I noticed that site notices have been posted as well, so my thanks to whoever did that. In terms of representations that have come in as a consequence of those notification letters and site notices and so on, I've got copies of all of those, both in respect to the appeal notifications and correspondence and in respect to the consultation on the original planning applications. Just reassure everybody, particularly interested parties, residents of Wrington, I will take all of those into account and into consideration, both those made at the planning application stages and at the appeals stage. So if you're wondering about that and whether or not to speak, I can assure you that whatever you've already put in will be taken into account by me in my decision. In terms of the proofs of evidence, I've got copies of all of the evidence of the parties who are formally calling witnesses, so I'll expect that to be largely taken as read. I'm sure you would have told me by now, but I'm bound to ask, have you all got each other's proofs of evidence, and is anybody missing anything, I suppose is the point.
So I think we have. Can I just check you got the 2 rebuttals, Mr. You have?
Yeah, I have. Okay.
We haven't got any of the other parties' opening statements. Sorry, if that was...
So the openings, well, they tend, if I'm anticipating them to be quite short. So if they're not been produced in writing, and sometimes they are, we'll find out shortly. If they're not been produced in writing, I wouldn't normally have a copy, but certainly closings will be in writing. But I do like them, openings in writing if they're available, and no doubt if they are available, they'll be circulated to everybody. Yeah, I think I'm right in saying that all the inquiry material is on the council's website and accessible via the applications page via a link, and I tested it yesterday and it seemed to be working for me anyway, which is very welcome. My thanks to whoever did that on behalf of the council. So yeah, if you're in the room or following along at home and you want to look at the documents that are being referred to, that's quite a neat way of finding everything. I think it's quite intuitive, but if you're struggling, perhaps you could give the council a phone call and they'll be able to assist.
Forgive me for jumping in. Just for clarity, I think tracking the proofs down is not so straightforward. So the core docs are on the website. The proofs, I'm told, are on the application page of the website. Whether it makes sense to say that all documents are in one place, if the council could electronically transfer the proofs to the core doc website as well, that would perhaps make it easier for those accessing remotely to get access to both the proofs and the statements of common ground.
That does sound like an ideal world. How feasible that is, I don't know. But
yeah, it's just the duplication would cause us some problems. What we have had added late yesterday is a link from the inquiry page with a section called Proofs of Evidence, and it's got a link across to the case file, which is where those are.
Okay. Yeah, that is helpful. Thank you for that. It's yeah. I mean, my sort of benchmark is me. If I can get it to work, I think most people who have got a bit of tech savviness about them will be able to, but I appreciate that's not everybody. But hopefully, if you are struggling, you know somebody who does have a bit of tech savviness who will be able to assist you. But it felt quite intuitive to me and quite descriptive with the addition of that link, which is much appreciated. Okay, I think I'm right in saying for people in the room that there are also documents. Have I got that right? That if people do want to have a rummage, where are they? Okay, they're just over to my right, if you do want to lay your hands on things.
They're behind me, sir.
They're behind you. Yes.
Somewhere there.
Yeah, excellent. Thank you for that. In terms of procedure, we'll follow the procedure from the 2000 inquiry procedure rules, broadly following the approach to hearing the evidence that I set out at the case management conference, albeit that the landscape evidence will be heard first due to the availability of witnesses. I'm mindful that people here and watching online won't be familiar with what those rules are and what we discussed at the case management conference. So I'll take a moment to just walk through those so everybody knows what to expect over the next hours and days as we progress through the evidence. It's a 6-day inquiry, or rather 6 days have been set aside for it. 4 days this week and 2 days next week, that's to say Tuesday and Wednesday. This morning, once I've concluded my opening remarks, which I'm nearly there, shouldn't take very long now, I'll invite the appellant, then the council, and then finally Keith Wrington as Wrington, to each make a brief opening statement. This will help everybody understand what the main arguments are for each of the main parties. In terms of a general running order and format, I anticipate that to hear from the three landscape witnesses, in turn, firstly Mr. Etchells for the council, then Mr. Dorr for Keith Wrington as Wrington, and finally from Mr. Leahy, is it? Mr. Boyle, have I got that right? Lié, excuse me, I'll probably get that wrong again at some point. I'll try my best, Mr. Lié, my apologies. Okay, well, I'll try and stick to Mr. Lié, but I do try to get pronunciation right. So if I am getting anything wrong, be it a place name or a person's name, don't suffer in silence. Please let me know. Okay, we'll hear furtherly from Mr. Lié on behalf of the council. I don't expect to wrap up the landscape evidence today, so that I anticipate will extend into tomorrow. Tomorrow we're moving locale. We're relocating to the Memorial Hall in Wrington, where I'd like to hear the interested parties who'd like to speak before we return to Mr. Lié's evidence. On subsequent days, we'll return here, and I'll hear from the council's remaining two witnesses, then from Keith Wrington as Wrington's remaining witnesses, followed by the appellant's remaining witnesses. I think by that stage, we'll just need to review where we are in terms of the witnesses, bearing in mind Mr. Jones's availability. But all being well, we'll have heard from everybody, bar Mr. Jones and Mr. Marsh, by the end of this week. But we'll see where we are. Once the appellant's witnesses and evidence have concluded, we'll have a session on conditions. That'll be a round table session, which is perhaps a little less formal from the inquiry process, more of a discussion that I'll chair concerning the suggested conditions in respect to each appeal and the proposed legal agreement in respect to Appeal A. I'll come back to conditions in a moment. On that basis, I anticipate that I'll hear the closing submissions of the main parties on Wednesday of next week, starting with the council, then Keith Wrington as Wrington, and finally the appellant. And yes, of course, I'll keep all of that under review, so perhaps not tablets of stone, but just to give everybody a feel for how things are likely to progress. Returning to the conditions and planning obligations, it's worth stressing that is absolutely standard procedure. It happens at all public inquiries and hearings for that matter. There needs to be a conversation about those because there is a possibility that planning permission will be granted. So we just simply have to have that discussion to deal with that scenario. What it doesn't mean is that I've made my mind up on the case. It's certainly not the case that I have. Nor will it undermine any of the parties' positions if they engage with that process. So if you've got any reservations, particularly looking at Keith Wrington as Wrington, I'll understand it if you don't want to engage with that process, but equally I would encourage you to be involved. A few points on conditions in 106 before I go back to procedure. There is a schedule of suggested conditions for each appeal. That's contained in appendices 4 and 5 of the Statement of Common Ground, if anybody wants to look at those. I understand they've been agreed between the appellant and the council, with the exception of one condition, that's condition 5 of Appeal A, concerning the provision of the pedestrian and cycle link, which I think is effectively the Appeal B scheme, linking to Westwood Close. I think in short the council thinks that condition 5 is necessary, whereas the appellant doesn't. I'm sure somebody will tell me if I've got that wrong at some point, but I'll continue to work on that basis. There is reference in the Keith Wrington as Wrington Statement of Common Ground to conditions, but no agreement as such. So I'm not inviting comment now, but as I said before, it's, if you do want to engage with that process, I'd encourage you to do so. It absolutely won't affect your position or your case that planning permission shouldn't be granted. Okay. I've also been provided with what I think is a well-advanced version of a draft Section 106 legal agreement in respect to Appeal A. That was, well, I think it was sent on the, I don't know what the date on the actual document is, but it was sent on the 16th of June. At some point, I'd like an update on where we are with the 106. If it's a short one.
No, so yes. So my instructions are that the version which I can hand up today has been agreed. I can't tell you as I sit here how it may differ from the version you had 16th of June, but the version you'll get is agreed. It's not signed, obviously, and we'll need to address you on that in a moment. But you will at least will be able to have the document that we'll be working to.
Okay, that's helpful. Thank you for that update. Yeah, and pursuant to to that legal agreement, I've also been provided with a SIL compliance statement prepared by the council. That's dated the 14th of June. That's helpful. My thanks to whoever was involved in putting that together. They are useful documents, those things, and certainly of assistance to me. If I've got any initial thoughts on the Section 106 agreement, I'll endeavour to communicate those in advance of the roundtable session in an attempt to streamline the discussion. I think there's nothing worse than an inspector pointing at any issues in the thick of that session. It's far better to flag them in advance so you've got a chance to deal with them. I'll do similarly with the conditions. Although a couple of things have already caught my eye, which I'll mention now. I'm not really seeking feedback on these now, but I'd like you to go away and give them a little bit of thought. Appeal A, condition 23, refers to building regulations, and I'm sure at least some of you are aware planning conditions shouldn't normally refer to other legislation, regulations, regulatory control, I should say. So I'd like you to think about whether the condition is A, necessary, or whether or not the wording is quite as it should be, or whether it could be improved upon in order for it to meet the conditions tests. Regarding condition B, I think this is possibly just a typographical point. The numbering jumps from condition 6 to 8, so either that's just a glitch with the numbering, or somehow condition 7's fallen out of bed. Or I've just got a rogue version of the document. I don't know what one of them, but if somebody can apply their brains to that and let me know which one of those scenarios it is, I'd appreciate it. And I may already have this, but might just be that I've not picked it up yet. It might be buried in the Statement of Common Ground. But if I've not already got it, could the appellant give me express written consent in respect to the imposition of any pre-commencement conditions? There are at least some pre-commencement conditions, and I think it's probably worth holding off until we've had the roundtable session to put that in, because the conditions might change in light of that session. But if somebody can make a note of that and ensure that that comes in, that would be appreciated. Okay, I'll return to procedure now. If anybody intends to make an application for an award of costs, this should be done before I close the inquiry. In addition, I have the power to initiate an award of costs, whether or not any applications have been made by the parties. If I were to do this, it would follow a written process with the relevant party after the appeal is issued. As I said earlier, although I've been to have a look at the site and the surroundings and the village, I will have to additionally conduct a formal site visit at some stage. I think that's likely to be after the inquiry closes, but we'll see how the time pans out later in the week. I mean, it's probably worth just explaining what I've seen, particularly as we're going to be hearing landscape evidence. What I did was I walked. Helpful if I had a map. Let me have a look. so I can describe it to you. Yeah, there's a right of way to the south of the village, to the south of Cox's Green. So I walked that. That's south of where the recreation ground, and it's not really a recreation ground. Travers Perkins and Buckcombe Brewery are there. So it's to the south of there. So I walked west along that right of way towards the appeal site. On the OS map it says Beam Mill. So I sort of walked to the north of there, came out onto the road, which is immediately to the east of the site, and crossed and continued along the permissive footpath that goes to the south of the site. Continued along that, and then walked southward at the end there. I think there's a brook, not that you can see it readily, but I followed a brook on my right and walked down back down to the road and returned to Half Yard, and then walked up Half Yard, and then walked up into the village and walked along the leg of roads that ultimately goes to the sewage works and the old railway line. Walked along there to see where the Appeal B site is, and then I had a potter around the village and came back. Oh, I also went to the churchyard as well. I had a look around the churchyard and out from there. But that was really just to get a feel for the lay of the land on my own. I will be doing a full site visit as part of the inquiry process. At this stage, as I said, I expect that to be next week, probably after the inquiry closes. I anticipate it's going to have three elements to it. The first on site, the second viewing from private properties, including neighbouring properties. I've had requests from 4 people to look at the site from their property, which I don't see any issues with, but obviously I'll have to be accompanied for that part of the site visit and the on-site element. I think I'm likely to want to see some long views as well, which is the sort of third element of the site visit. My experience is that they can be very difficult to coordinate with a number of people, and because there'll be public views, there's no real need for me to be accompanied. So I do that element on my own on an unaccompanied basis. But what's very important is that there's agreement between the parties that I see what you want me to see. So I think of the CMC, I requested a sort of an itinerary for that, and I've seen a draft, but I've not seen anything that's sort of agreed between the parties. Do we have a position on that?
So there is indeed a draft that's travelling between the parties. I think there was an issue about how one gets from A point to B point, but we'll make sure that's finalised before
Okay.
you embark on your tour. There may be some nearby views that we'd like you to be accompanied on, and then yes, of course, the longer distance views you can do unaccompanied, but subject to that plan. So can I just, while we're on site visit, I know you were there yesterday. I've asked that the edge of the site be marked out with an electric fence, so that when we do the site visit, you can actually see how far the site extends. Because certainly when I went recently to see the site, it's not very clear on the ground, although there's historic indication on the maps as to where boundaries were. There isn't visible on site at the moment, so we're having that pegged out.
Okay, that would be helpful, and hopefully it won't be contentious in terms of agreeing that that's the correct alignment. Presumably, it's being surveyed to make sure that it's going to be correct alignment, and hopefully they won't switch it on. I won't go too close, just in case. It's worth saying before I move on from the site visit, it is purely for me to see the site. It won't form part of the evidence-giving part of the inquiry. So while I will be accompanied by the 3 main parties, what I won't be able to do is hear evidence. I mean, if there's a matter of fact like Mr. Jones, that's the tree that was alluded to in evidence, that's absolutely fine. But what I can't hear is, here's the wonderful, magnificent tree that will ruin, you know, I can't hear that kind of evidence. So we need to hear the evidence in this room following the due inquiry process. Okay, we'll move on. Yeah, and just in terms of the rhythm of the inquiry, I'll look to break for lunch, probably around 1 o'clock, and have breaks in the morning and in the afternoon sessions. Probably one mid-morning, probably one mid-afternoon. It'll be partly dictated by natural breaks in the evidence, but if I can ask the advocates to assist me when you're dealing with witnesses to identify suitable breaks, that would be helpful. I think on subsequent, we've obviously started at 10 o'clock today. It's my practice to start at 9:30 on subsequent days, just really to make the most of the time. Will that present an issue for anybody if we were to start at 9:30 on subsequent days? No. And tomorrow's venue's it's not that far, and it looks relatively straightforward. I had a quick look from the exterior yesterday, so I don't anticipate a problem. So we'll do that then. Thank you. In terms of the plans, they're identified in the statement of common ground, so I won't drill into those. I think that very briefly for Appeal A, it's the site location plan that was submitted on the 1st of December 2020, reference 0701-101, and secondly and finally the proposed access arrangements which were submitted with the appeal. That's P19-2039 figure 2. Appeal B, it's the location plan. That's reference 0701-101-3, and the detailed drawing, which is reference P19-2039_01. Now, I'm obviously mindful there's a lot more material above and beyond all of those, particularly for Appeal A, which are sort of indicative drawings in respect to Appeal A. I'll obviously bear those in mind as part of my decision, and I'm mindful they're alluded to in the conditions. In terms of documents, we've already touched on these. I think with the exception of the site visit itinerary and the final version of the section 106, I'm not aware of anything else that's outstanding, but is there anything?
Raise three things, I think. So we've mentioned the 106 that you'll get shortly. You will also see in reference to easements in respect of the Appeal B scheme. We have 2 of those signed, and another is being signed, and you get the signed copies in due course.
Okay, thank you.
You may have had sent to you, or you may not, the recent Farley Farm decision, one of your colleagues. Certainly we have copies of that if you don't have access to it, because it was too late to get into the core docs.
I think
so we have that.
I think something came in on Friday, and bearing in mind, or last week anyway, bearing in mind that was an inspector decision, and it came out when it came out. I understand why it's only come in now, so I was content for that to be admitted.
So you'll get that, so thank you very much. You should, I hope, already have received a 2-page agreed blue document that looks like that. It's the comparisons between the parties' landscape witnesses. That's an agreed document, and it's just to aid the process. And then we've also produced, principally for your site visits, the landscape pictures, the photographs. At the moment, I think you have them probably in A3. Strictly, they should be presented at A1, so you can hold them in accordance with the rules. We only have 2 sets of those. We're not proposing to make use of them in the inquiry, but there is a set for you to take on your site visits, so you can do that exercise. Everybody else will be working to the A3 versions, which are in the appendices.
Okay, that's helpful. Well, I don't see a need for those to be put in now, but if they can be brought along to the site visit, and we can all look at those in situ.
So the only other thing to mention, and it was raised with me by my learned friend, is apparently in the core docs we're missing one because it was thought to be duplicated, and that's the relevant extract of the landscape sensitivity study. And I understand the council have copies of the relevant parts for you.
Yes.
As if by
So
magic.
can I just explain what's happened?
Yeah.
As my learned friend says, the supplementary planning guidance dealt with by Ward and Armstrong is in the core documents. The sensitivity assessment was intended to be copied separately, but what I think happened was that there was a mistake, and it was thought that the two documents were the same. And so if you go to one of the core documents, B2 I think it is, you will find the supplementary planning guidance there. Later on, F4 or somewhere round about there, there's another reference, and that simply refers you back to B2, which shouldn't have happened. Right. So what we've got is, first of all, the plan which the Wardell Armstrong sensitivity assessment refers to, and I've got copies here, and I'll sort them in a moment. And we are also having copied the relevant section of the Wardell Armstrong sensitivity assessment that relates to Wrington. We're not copying the whole document unless somebody badly wants it, because it's 109 pages, and that seems a touch excessive. But we will have a copy of it available, should that be necessary. At least I think it probably won't be.
Could we just also add, so the methodology, so if we have the methodology, the Wrington chapter and the relevant map?
Yes.
That'd be helpful.
Right, okay, well, can we have the methodology bit copied as well? Yes, we'll see to that. Meanwhile, I've got a copy of the map, which...
I don't know yet. Was that included in?
That's you've got a copy.
Yeah, excellent. Okay, thank you.
Yeah. Sorry, I couldn't get A1.
Okay, can I just double check that you, Mr. Storey, do you?
I do apologise.
It's a bit of a walk. We could do with an electric train or something. Well, hopefully you've now got a full suite, Mr. Storey, but if you are missing anything, please let me know, and either now or at one of the adjournments.
Thanks, sir. At some stage, I would like to introduce just a pamphlet that's more to do with the conditions at the end, which we will be attending. Thank you for your invite. I don't know when that's a suitable option to pass to you.
I think I'm struggling to hear you because I had my mic on and you're not coming. So if I switch my mic off, I should be able to hear you.
Sorry, sir. So I've got a pamphlet that's just been handed to me that refers to Bronze Age, but it's to do with more to do with the conditions which we will be, taking part in, as you've mentioned earlier. So I don't know whether this is the right time to pass these up to you.
I suppose it depends on what it is. Is it something that you can just deal with orally as part of the condition session? Without, it's like anything. Unless you know what it is, it's difficult for me to comment. Then once I've seen it, it's difficult for me to unsee it. It's
okay. Yes, I understand. So if I were to take the break and pass it to the council, just so they could see both councils and they can see what it refers to and try to explain why we think it's relevant.
Okay, well that sounds like a sensible thing to do. So perhaps if you, during one of the adjournments, you can do that. And I think my reference earlier to using the adjournments to just to double check you're up to speed with everything, and then once we resume with the inquiry, you can let me know if there is anything that's missing. Okay, thank you. Right, we've done plans, we've done documents. That takes us to main issues and other matters. I think the main issues are essentially as they were identified at the case management conference, albeit that we've now got certainty on the omission of the conservation area from a council's case. Essentially, the main issues are intended to identify the distance between the appellant and the council. There are, of course, other issues at play from interested parties and from Keep Wrington as Wrington, which, of course, I will be taking into account. So these aren't exclusive. They're merely intended to identify where the council and appellant don't agree. So, what are they? For Appeal A, they are firstly the effect of the proposed development on the setting of the Grade 1 listed Church of All Saints, and as part of that, obviously I'll need to have a good understanding of the effect of the development on the significance of that as a heritage asset. Second is the effect of the proposed development on the character and appearance of the area. So that goes to all of the landscape and visual impact evidence which we'll be hearing today and tomorrow. And then thirdly, whether any harm arising would be outweighed by other considerations, including the absence of a national planning policy framework compliant supply of housing land. So that's Appeal A. As I've already alluded to, regarding Appeal B, in light of the extent of common ground between the council and the appellant, the main issue is whether or not there are any other considerations that might indicate that that appeal should be dismissed. Are there any comments on those as main issues? No? Okay. We'll pass, we'll move on. We're nearly there. I think we are there. Is there anything else that I've not touched on that anybody was hoping I might touch on, or you think I ought to touch on before we hear openings? No? Okay. Well, on that basis, it's now time to hear the openings. Firstly, for the appellant, Mr. Boyle, please.
So as anticipated, I've reduced the openings into writing. There's a copy coming to you and to anybody else who's interested.
Thank you.
So these opening submissions are made on behalf of the appellants in respect of an appeal against the refusal of permission for an outline application for up to 61 dwellings on land at Butts Batch, Wrington. That's your Appeal A. And secondly, against the non-determination of an application for footpath cycle link adjacent to Westward Close, Wrington. That's your Appeal B. Appeal A was refused for 2 reasons and is opposed by North Somerset Council. Appeal B is not opposed by the Council, but it is by the local action group Keep Wrington as Wrington, which we've fallen into the habit of calling QUAR. I don't know if that's an acceptable shortening of Keep Wrington as Wrington. If Mrs. Storer objects, I'll call it by its full name, but QUAR is what we've come to know it as.
I think most people have started to do that, so we'll go with that.
You're happy to do
Okay, thank you.
I didn't dare abbreviate it, but I was beginning to find it. Every time I was saying it, it felt more of a mouthful when I was saying it. So QUAR is welcome.
We had lots of discussions about it, so go ahead. Okay.
That's grand. Thank you for that.
I'm grateful for that. So Wrington, as you know, is classified as what's called a service village for the purposes of the core strategy policy CS32. And as such, it's agreed between the main parties that it is a sustainable settlement for housing growth. The site adjoins the adopted settlement boundary of Wrington and has ready access both along Butts Batch, which is to have additional footway provided, and by the link subject to Appeal B, to the facilities and services of the village within easy walking and cycling distance. Consequently, it's agreed that the site is locationally appropriate for residential development in terms of policy CS32, and so you'll have seen these agreements in the Statement of Common Ground. The policy CS32 is supportive of residential development within and adjacent to settlement boundaries of service villages such as Wrington, subject to 7 criteria, which the appellant considers have been met. The one aspect of the policy which is acknowledged is breached is the procedural requirement that schemes over 25 dwellings should be brought forward through local plan or neighbourhood plan allocation. However, that procedural requirement does not impose an overall limit on either the size of individual sites nor indeed on dwelling numbers to be provided at any given service village. In any event, there's no neighbourhood plan for Wrington, and the emerging local plan is at too early a stage to be accorded material weight. Consequently, it's only through an application, rather than allocation, that development at Wrington can be expected to come forward. The starting point, therefore, is that the Section 38(6) development plan is supportive in principle of additional residential development, including outside settlement boundaries, at Wrington, as a sustainable settlement for additional growth, and that this site is acknowledged to be sustainably located vis-à-vis that sustainable settlement. As such, it's notable and correct, we say, that neither of the Council's reasons for refusal object to the principle of development as being outside the out-of-date settlement boundaries. Reason 1 asserts a heritage objection, now limited to impact on the setting of All Saints' Church, and Reason 2 asserts a landscape objection. The matter goes further, however, we'd suggest. The North Somerset core strategy, adopted in 2017, is itself out of date. First, it's predicated on an assessment of development needs, that is policy CS13, which was acknowledged at the time not to be in accordance with the MPPF, but judged to be acceptable if subject to review by 2018, which has not taken place, and is now replaced by the increased requirement under the standard method. As such, its housing distribution under policies CS14 and CS32 is also out of date, as are the adopted settlement boundaries upon which the restraining policies operate. Those policies may, therefore, be accorded reduced weight as being predicated on an out-of-date assessment of development needs, and I've referenced there, Sir, the Hopkins-Holmes Supreme Court, which is in the core documents. Secondly, and in addition, in the light of 2 recent appeal decisions, the Council has been obliged to concede that it cannot demonstrate the required 5-year housing land supply. It's put either 3.2 in one decision and 3.5, sir, in another. And as such, footnote 8 of the MPPF is engaged, deeming the most important policies out of date, including, of course, CS32 and the settlement boundaries. Consequently, as it's agreed that CS32 is one of the most important policies, by both of these factors, it is out of date for the purposes of paragraph 11D of the MPPF. In such circumstances, consistent with the appeal decision in Cox's Green, also Wrington, breach of the procedural requirement that sites over 25 dwellings be brought forward through the neighbourhood plan or local plan process can only be accorded limited weight. It's a policy negative, but not one which justifies the withholding permission for sustainable development. So as to heritage, reason for refusal 1, the Council has now abandoned its objection in respect of the impact of development in the setting of the conservation area. We'd suggest it's right to do so. The appeal site sits removed from the conservation area, separated from it by undistinguished 20th century development. The Council maintains its objection by reference to impact of development in the setting of the All Saints' Church, notably the tower. But even then, it only asserts less than substantial harm at the, quotes, lowermost end of the scale. Again, that's in the Statement of Common Ground. This is agreed in the appellant's heritage statement and triggers the operation of paragraph 202 of the MPPF, where such heritage harm is to be weighed against the public benefits of the scheme. So the matter, of course, will be explored in evidence, but suffice to say at this stage that even with the Barnwell approach, this lowermost end of less than substantial harm is, we'd suggest, decisively outweighed by the manifest public benefits of housing and affordable housing in the context of deficits against deficits in both against need. The economic contribution, the landscape improvements, and the significant biodiversity net gain achieved. Accordingly, the requirements of paragraph 202 are met, and the proposal is policy compliant as regards heritage impact. As to landscape matters, reason for refusal 2, The Council acknowledges the site is not part of a, quote, valued landscape for the purpose of paragraph 174A of the MPPF. Moreover, policy CS32 is predicated on the acceptability of a degree of landscape and visual harm, as must inevitably arise when developing a greenfield site outside the settlement boundary. Localised landscape character and visual impact is to be expected, therefore, and is not a reason for withholding otherwise beneficial development. Indeed, this is a scheme which is and will always be seen in the context of the existing and architecturally undistinguished part of the village, and brings with it notable landscape improvements, not least the reinstatement of lost historic field boundaries and planting to soften what is currently a stark settlement edge. Consistent with the MPPF's beauty agenda, considerable care has gone into the placemaking aspects of the scheme to create a proposal that will enhance the settlement of Wrington rather than detract from it. Consequently, so as will be explored in evidence, breach of the procedural requirement within the out-of-date CS32 should not be a barrier to sustainable development here. Paragraph 11D is engaged, and Heritage Matters did not provide a, quote, clear reason for refusal under paragraph 11D(1), taking USO as a decision-maker into the tilted balance under paragraph 11D(2). Weighing the many and manifest planning benefits against the limited and localised adverse effects, this is a scheme which we suggest should be in due course allowed, and permission should be granted in the public interest.
Thank you, Mr. Boer. Can we hear from you now, Mr. Wardsley, for the council? Thank you. It's very welcome.
So the appeal proposal as amended seeks the grant of permission for up to 61 dwellings on an area of agricultural land outside the settlement boundary of Wrington to the southwest of the village. As well as being in the open countryside, the land is part of the setting of the prominent Grade 1 listed All Saints Church to the north of the site. Wrington is classified as a service village dealt with under policies CS14 and CS32. Policy CS14 states that there will be opportunities for small-scale development at service villages either within or abutting settlement boundaries, or, importantly, through site allocations. Policy CS32 builds on this by stating that, quote, sites outside the settlement boundaries in excess of about 25 dwellings must be brought forward as allocations through local or neighbourhood plans. The proposed development is considerably in excess of this figure. This figure is not a procedural limitation, which is the appellant's approach, but one which is intended, under the present up-to-date development plan, to deal with a situation where service villages are at the lower end of the settlement hierarchy. They have a limited capacity for growth, limited services and facilities, and supporting infrastructure, for example, public transport. They lack self-containment and would not reasonably be regarded as sustainable at the level of development proposed. The local plan inspector, when considering and approving this policy, was firmly of the view that it allowed necessary flexibility while preserving the character of service villages like Wrington. He observed that larger unallocated development would present a significant risk to the spatial strategy. It is, this is what he said, entirely appropriate in accordance with the plan-led system that larger sites should be brought forward in local plan or neighbour plan allocations. That the Council has demonstrated flexibility in line with the intent of the policy is demonstrated by the development of 59 dwellings at Cox's Green, which of course is ongoing at the moment, and the grant of permission for up to 38 dwellings at Gatcombe Farm, close to the village, and I footnote the observation that its previously developed land actually dealt with under a different policy. The policy has not been treated as a means of frustrating development. Numbers apart, this development is also contrary to various criteria of CS32, that, among other things, development should, I quote, respect and enhance the local character and should have high-quality schemes which are, I quote, appropriate to its context and make a positive contribution to the local environment and landscape setting. The development does neither of these things, as will be demonstrated. The clear intent of policy CS32 is that development of any size greater than the policy parameters, such as the present appeal, should be dealt with through the local plan process. This cannot be dismissed as a procedural approach. It is obviously sensible because it allows for sites to be considered with other sites at other locations which may be more suited to development of the relevant size. This shows the development plan process operating appropriately, allowing local input and not undermining the local plan process. It's clear that not only is there a conflict with policy CS32, but that the development offends the relevant policies on heritage and landscape. The setting of the Grade 1 listed church, with its magnificent, prominent tower, in the centre of the oldest part of the village, dominates the countryside. It's a key landmark. Its significance is added to by its setting, of which the appeal site is part, where its architectural significance and its place in the landscape and the village can be appreciated. The effect of the development will result in the severance of sightlines for the tower and a reduction in the area where the architectural significance of the church and its position in the landscape and the wider rural area can be appreciated. The Council's position, through Dr. Hudson Macaulay, is that the harm is at the lower end of less than substantial harm. That said, great weight should be given to the asset's conservation, and the more important the asset, the greater the weight should be. That's the framework. This is one of the most important heritage assets, a Grade 1 listed building, and the fact that it is such is highly material. One should add to that what is said in the cases, namely that the finding of harm to a designated heritage asset gives rise to a strong presumption against the grant of permission, and I footnote the reference to the Barnwell case. There is, of course, a balance to be struck, the harm being weighed against any public benefits of the scheme, and this will be dealt with below. The development would also be contrary to policies CS5 and DM4. As to the landscape, there's a significant impact both on landscape character and views. Mr. Etchells deals with this in some detail. As he points out, there is a North Somerset landscape sensitivity assessment carried out by Wardell Armstrong in 2018. This shows that the sensitivity of the site of the land close by to the west, south and north is high. Furthermore, the separate landscape guidelines for the area indicate that the rural pastoral character of the area should be conserved. And of course, the area of the site and around it is largely of a rural and pastoral character, albeit the village is present to the northeast. It must be remembered that the proposed development of 61 dwellings up to 2 stories in height will be highly visible and indeed prominent because it will run across a locally prominent ridgeline. A large part of it is on a south-facing slope, which is itself prominent in views towards the Grade 1 listed church from various approaches to the south. It is not a site which is generally well contained and is open to views from the west and south. The result is that the development will be visible and often prominent from areas around the site. Mr. Etchells assesses the impact on the character of the landscape of and around the site, given its sensitivity and value, as having a moderate to high adverse effect. While the effects might decrease over time with the maturing of planting, they will never disappear completely. As to visual impact, there will be significant adverse visual effects for the residential properties close to the site and the uses of public rights of way around the site and those passing along the adjacent roads, Half Yard and Butts Batch. Overall, Mr. Etchells considers that the effect on the character and appearance of the site is that there will be a significant long-term harm in all of these respects. Much of the rural character and landscape setting at this point will be significantly diminished and replaced by built development, and the development would obstruct many of the views to the church from the area around the site and significantly change the context of any which remain. That assessment shows that there is an overlap between the landscape and heritage issues insofar as they affect any impact on the Grade 1 church, and emphasises the importance it has in the landscape. In short, the development is contrary to policies CS5, 32, DM10 and DM32, together with the relevant parts of the framework as referred to by Mr. Etchells. The harm to the Grade 1 listed church and to the landscape combined with the conflict with policy CS32 provide proper reasons for dismissing this appeal. Plainly, as against that, the advantages of the residential development, particularly where there is not a 5-year housing land supply, must be considered. The Council has between 3.2 and 3.5 year housing land supply, depending on whether the conclusions of the Rectory Farm or Backwell appeal decisions are accepted. In either event, the shortfall is highly material. Footnote 8 of the framework is engaged. Mr. Reynolds correctly observes that significant weight should be given to the benefits of providing both market and affordable housing. He has dealt with other benefits of the development, which in his view attract either moderate or limited weight, some because they are either in reality means of mitigating the effects of the development, for example, provision of open space, or because they are temporary or transient, for example, construction jobs. The harms have been referred to above. The development is clearly contrary to the adopted settlement hierarchy in an up-to-date local plan. It would cause less than substantial harm to the setting and significance of the Grade 1 listed church, and it would also have a significant adverse impact on the landscape character of the area and also on views over that landscape. Mr. Reynolds is right to attribute substantial weight to both these harms. Footnote 8 being engaged means that normally the tilted balance would apply, and the issue would be whether the harms significantly and demonstrably outweigh the benefits of the development. However, it is accepted that there is less than substantial harm to the setting and significance of the Grade 1 church, a designated heritage assets. Accordingly, where the application of policies in this framework that protect areas or assets of particular importance provide a clear reason for refusing the development proposed, the tilted balance is not applied. In this case, under footnote 7, there's a designated heritage asset which suffers harm from the development. The framework policies relating to heritage assets, namely paragraphs 199 and 202, provide such a reason. The position is therefore that the tilted balance is not applied, and it must be decided whether the harm to the heritage asset outweighs the benefits of the scheme. If it does, the appeal fails. If it does not, it is then necessary to consider whether all the harms from the development outweigh the benefits of the scheme. This exercise would include any heritage harm. In carrying out the exercise, the tilted balance will be applied. It is a submission of the Council that whichever test is applied, the appeal fails. Concentrating on the tilted balance, the harm to the setting and significance of the Grade 1 church carries substantial weight, as does the harm to the landscape as assessed by Mr. Etchells. Combined with a non-compliance with policy CS32, they are sufficient to significantly and demonstrably outweigh the benefits. For these reasons, this appeal should be dismissed. And by way of postscript, the Council does not contest the appeal in relation to the northern access to the site, Westwood Close, subject to the application of a gramping condition for its implementation and any other necessary conditions. And the Council has also altered its position on the issue of harm to the conservation area. The reason for refusal referred to such harm. However, in the course of the appeal, the appellant has provided a revised layout with smaller dwellings with lower ridge heights and has limited the amount of development in the southern part of the site. Subject to appropriate conditions, the Council considers that the harm to the wider setting of the conservation area is sufficiently mitigated, and I give you a reference to what Dr. Hudson Macaulay says about that. And so those two matters deal with two of the matters you raised in opening. So that's what I have to say.
Thank you very much, Mr. Wadsley. Can we hear from you now, Mr. Storer, on behalf of Keep Wrington as Wrington?
Just wait a few seconds while we hand round the copy, sir.
Whenever you're ready, please.
Thank you, sir. Keep Wrington as Wrington is a local residents group, and we are here to represent the local community who have submitted over 800 objections to this proposed development, and we oppose the appeal. We would like to thank the Inspector for granting us Rule 6 status, which has enabled us to be involved throughout the appeal process. And I wish to start by pointing out we're disappointed that the developer has made this appeal, given the university negative responses to their plans. The local community has already made it clear they do not want this development for a wide variety of reasons, not least that they consider it inappropriate in both size and location. With regards to a PLA, our evidence seeks to further support the council's position by supplying evidence from residents who have lived in Wrington for many years. Our evidence will set out the following. The proposed development will destroy the beautiful landscape that encloses the historic village of Wrington. This will then remove the tranquil setting of rolling countryside called Wrington Vale, in which the village nestles. The urbanisation of the Wrington Vale landscape at the southern gateway to the village will create a very large and bolted-on housing estate set on the highest point in the landscape. This will overpower and dominate the village and remove all sense of its old English village attractiveness, and will have a substantial impact on the conservation area as well as on the Grade 1 listed All Saints Church. The appellant admits that it will cause harm to the countryside, but then argues that it is not too bad and, whatever the damage, will use the lack of housing supply to push this development through. We maintain that any harm is too much, and note that the appellant's expert witness, Mr. Lay, has now made a last-minute acknowledgement that the site is designated as one of high sensitivity. We contend that this proposed development does not satisfy the National Planning Policy Framework test for being sustainable. A representative from the Council for Protection of Rural England will also give evidence that this development will create urban sprawl, increase light pollution, is not plan-led, and it is a speculative development on land that has not been put forward for development. It goes against the existing local plan and does not conform to numerous national and local policies. We will also be setting out how the proposed site is on good agricultural land, despite the grading attributed by the appellant. Again, local knowledge and what is witnessed by residents is at odds with the appellant's data. This local knowledge will also show that the proposed drainage scheme will be attempting to drain into land that is already flooded, so it's an unsatisfactory proposal and could lead to flooding elsewhere. With regards to traffic and pedestrian infrastructure, we will show the reality of pedestrian access to the village from this site is not safe due to traffic volumes at peak times along the only road that accesses the proposed site. This pedestrian access is constrained by the way the village has evolved over the centuries, and this is already unsafe and impractical for anyone with small children or who has a disability. The addition of hundreds of extra residents on the proposed site will only increase and exacerbate this danger that it already exists. The proposed development site is further than the recommended 800 metres to the centre of the village. All these facts will lead many of the residents to use their cars. With national data showing that there is an upward trend in the number of vehicles per dwelling, this will cause more traffic and danger in the narrow streets of Wrington, along the only access road through the neighbouring village of Lower Langford, and the small lanes in and around the village before it is able to access either the A38 or A370. It will also reduce air quality in the confines of the village and create a large increase in CO2 emissions. Appeal B relates to a subsequent application submitted in July 2021, 9 months after the original application. It is the result of one of the requirements set out by the design review panel from a long list of improvements that should be made to this project if it were to be progressed. In a bid to gain better connectivity to the village to the north and northeast of the proposed site, the appellant submitted a proposal for a footpath link into Westwood Close, and not Westwood Close as put on the appellant's original application. Westwood Close is in Wall and not Wrington. This is a perfect example to illustrate that this documentation was hastily assembled, poorly presented, and contains misleading data. The appellant has very recently attempted to shore up this application with the addition of documents allegedly proving ownership. We contend that this claim does not stand up to even the most cursory examination. We will provide evidence to show that this is not a safe or satisfactory pedestrian link to the proposed site, and no consideration has been given to the negative impact that this will have on adjoining residents. It will reduce their residential amenities by increased noise and disturbance from movement to and from the proposed site at all hours of the day and night. Nor can the appellant meet the conditions already set by the highways. We maintain that without this link, a PLA cannot be shown to be connected and integrated into the village. We maintain that this is a deficiency in the original application as commented on by the Design West review panel. The appellant will have failed to show that they can provide this required connectivity, and therefore the proposed site is not a natural extension of the village that could be easily assimilated into the existing structure of the village. Yet in the statement of common ground, the appellant states that this link is not necessary. And if this is so, why are they wasting the inspector's time and public money by appealing it? In both matters, we will set out the facts that as they pertain to residents whose real-life experience carries more weight than the appellant's remote desktop analysis. Anything is possible in theory and can look good on paper. However, what happens in the real world is what counts when shaping the future of those who will have to live with this large, urbanising and disjointed addition to the existing village boundary. We note the appellants already submitted a rebuttal document to the inspector which seeks to debunk much of our witnesses' evidence as merely lay and uninformed opinion. We contend that our witnesses' testimony is relevant and should be given full weight in deciding the outcome. Therefore, sir, at the conclusion of the inquiry, keep Wrington as Wrington will invite the inspector to dismiss these appeals.
Thank you, Mr. Storer. I think what we'll do is take a short break now and allow the witness to set up. Squinting at the clocks, we've got 2 clocks, but are slightly different. And I've got a third time on my laptop. There you go. My laptop says it's 16 minutes past. Let's take a nearly 20-minute break to 25 to. And resume then, and if the first witness, Mr. Etchschools, can use that break as an opportunity to get himself set up, and we'll go straight into evidence in chief, please. Okay, so we'll adjourn now and resume at 25 to. Thank you. You can find your seats, please. Thank you. Yes, it is now 25 to. The inquiry is resumed. Scanning the room to double check everybody's here who should be here. I think we're a full complement. So on that basis, can we start with your first witness, please, Mr. Wadsley?
Sir, certainly. Mr. Etchells is in post. I'm going to have to swivel around slightly, but never mind. Before introducing him in the conventional way, can I indicate that what we'll probably need is the LVIA, the wireframes, obviously Mr. Etchells' proof and appendices, Mr. Lea's proof and appendices, and the sensitivity assessment of Ward L. Armstrong. And the position about that, sir, is that we have had copied the plan, which you'll have seen. We've also had copied, it's actually only 2 pages, pages 51 and 52, the Wrington assessment by Ward L. Armstrong, and as requested by my learned friend, the methodology in section 5 that Ward L. Armstrong used.
So that's everything that was circulated this morning, plus the methodology?
Yes, I hope that's what it is. I'm saying all this with all caution. So if anybody hasn't got things, they can tell me.
Okay, well that's a fair comment, and I'm not seeing any concern around the room, so I'll work on the basis that everybody does have that.
So thank you very much indeed. So,
I mean, in terms, I've not got everything out, but perhaps as we work our way through, if you can remind me where I can find things. Well, I mean, the most recent stuff's immediately to hand, but the wireframe and so forth. But let's do that perhaps one at a time.
oh yes, of course. I was just indicating in general terms what we'd need.
I'll be ready. Thank you.
Yes, thank you very much, sir. So I'll introduce Mr. Etchells, if I may. Mr. Etchells, is it John Etchells?
Yes.
You're a director of John Etchells Consulting Limited, which is a registered practice of the Landscape Institute. You indicate you've got an MA in Geography from Cambridge University, a BPhil in Landscape Design from Newcastle upon Tyne University, and you are a chartered member of the Landscape Institute. And is all that correct?
It is, yes.
Thank you. And in paragraph 1.2 of your main proof of evidence, you indicate you have over 35 years' experience of landscape assessment and design, and you set out in that paragraph, and I don't propose to go through the detail, but you've undertaken landscape, townscape and visual assessments for many housing projects in various parts of the country. And you indicate in 1.3 the those for whom you have provided landscape evidence, local authorities and developers, particularly in the past. And is all that correct?
It is, yes.
Thank you. So you have bound up in your proof of evidence a summary proof, which is at section 8, page 44. Perhaps you could be kind enough to go to that. And what I'm going to ask you to do is to read it, so those listening to and watching the inquiry on live stream can understand what your evidence is. And then I'm going to interrupt you at various points and ask you to amplify various matters. So if you'd start at 8.1.
The site for the proposed development partly adjoins, but is outside the settlement boundary for Wrington and is therefore in the countryside. The site comprises the eastern parts of 2 large arable fields separated by a hedgerow and ditch, though there would be no built development in the southern field. The northern field adjoins existing houses at the west end of Kings Road in its northeastern part and is immediately to the east of Half Yard in its southeastern part where the access is proposed. The western site boundary is unmarked on the ground and runs across the open fields.
Within the southern field, the site extends as far as the tree-lined course of the River Yeo, and this part of the site is proposed for ecological mitigation and a drainage outfall to the river. The southeastern part of the site is close to the boundary of the Wrington Conservation Area, which at its closest point is around 35 metres from the site on the opposite side of Half Yard, Butts Batch. The Grade 1 listed building of All Saints Church is on the west side of Station Road, close to the village centre, around 210 metres to the north-east of the site, and the site provides a foreground to attractive views of the church tower from the south. Around the site, the high ground of the Cleeve Ridge forms an attractive backdrop to the village and views from the south, and also affords expansive views to the south over the village and the site. The Mendip Hills area of outstanding natural beauty lies to the south of the site, with the closest point along its boundary on the south side of the A368, around 2.8 kilometres to the south of the site.
Could I, perhaps you could help us by looking at some of the photographs that you have provided in your appendices, and perhaps you could take us to those that you think would most assist in dealing with the character and the quality of the landscape that we're discussing in this inquiry.
Yes, I'll just go briefly to some of the photographs, which you'll have seen, sir, as you've been to the site. But I'll try to say in this sample of them, you'll obviously be able to see what the site looks like at the moment from the photograph, but I'll try and summarise what would happen to that view if the development were to proceed.
Yes.
So starting with photograph 1, this is from the permissive path to the south of the site along the south side of the river. This is through a gap in the vegetation, and this was taken before the trees were in leaf, so the views would be slightly less clear at the moment, but obviously the gap would still be there, and there are a number of gaps in the vegetation along the course of the footpath as it runs by the river. So in this view, we see the site where the built development would be just on the far side of the hedge, which runs across the view. Beyond the site, you can see some of the houses on the edge of the village, and you can see the church tower, obviously, in the centre of the view, with the wooded hills in the background. So at the moment, it's an attractive, largely rural pastoral view. But if the development went ahead, the field beyond the hedge, so the second field, not the first one, but the one just beyond the hedge, between that hedge line and the houses would be pretty much filled with new houses, which would run all the way across the view from left to right. I don't think the houses would completely obstruct the views of the church tower. I think the very top of the tower would still be visible. It obviously would depend exactly where the houses fall within the development. But there would be a significant change in the character of that view with new development spreading all the way across it. Photograph 2 is a similar view, but from Half Yard, just to the north of the bridge over the river. It's a similar view. The church tower can again just be seen where indicated by the red arrow, although it's partly screened by intervening trees in this particular view. But again, the built development would extend all the way across the view. I think one of the houses would be in front of the white gable, which you can see just above the Welcome to Wrington sign. That would be the easternmost house within the site, and new houses would extend all the way across the view, I think 2 or just beyond its left edge. And again, at the moment, it's an attractive, largely rural view with the church tower and the wooded hills in the background forming attractive components of the view. If we move on to photograph 16, that's just from slightly further to the north, closer to the entrance sign. Again, it's a similar view, it's just slightly closer, but what I'd say about this view is that because you're closer to the development, the new houses would appear higher in the view, and I think in this view, because you're closer to the new houses, they would in fact be taller than the church tower. There are some gaps allowed in the development to maintain some of the views to the church tower, but as I'll go on to say in a minute, those views would be quite narrow, and if you move to either side of the viewpoint, I think houses would in those cases be in front of the church tower. If we move on to photograph 19, this is from further to the southeast. This is to the east of Half Yard from the public footpath, which I think you said you walked along, sir. Obviously, in this view, the church tower is more distant, but it's still a prominent feature of the local landscape. The surface of the site can't be seen, but the roofs of the new houses would be visible above the intervening trees just to the left of the church tower, so there would still be some change in what is, again, a largely rural, attractive view, in my estimation. And then lastly, photographs 20 and 21 are just moving north towards the site along Half Yard. And they're part of the sequence of views you get as you move along the road, in which the church tower forms a focal point and comes in and out of view depending on the localised screening afforded by intervening trees. But as you move along the road, again, they are, in my view, attractive, largely pastoral views, with the church tower forming a central feature and the wooded hills forming an attractive background. In photograph 20, the new houses would be visible in front of the church tower, extending across the centre of the view. There'd be some localised filtering from intervening trees. And in photograph 21, because the view is a little bit lower down the road, the new houses would be less visible, but there would still be views of the roofs of the new houses in front of the church tower.
Yes, I mean, just help me with this. The land may appear flat if we look at some of these photographs. I mean, what is the position actually on the ground as far as the configuration of the appeal site is concerned?
Well, there's quite a pronounced local ridgeline within the site. If you turn to my figure 3, it may help, because that's on an ordnance survey base, and so it shows the contours. They're not incredibly clear, but basically the northern part of the site, where more or less where the apostrophe in Butts is on the ordnance survey mapping, is a local high point, and the land falls from that point towards the northern edge of the site, and also falls all the way from that point to the southern site boundary alongside the river. So what it means is that there's a local ridge which basically extends from just to the south of King's Road to the west across the site. If you're standing on Half Yard looking at the site, the ridge is quite apparent. It's also apparent in views from the footpaths to the northwest. And the point is that the new houses would extend along that ridge line. Some of the houses are 1 or 1.5 stories only, but most of them are 2 stories. And there would be new 2-story houses extending along that ridge line, which would increase their prominence in views towards the site, particularly from the northwest and from the south.
Thank you. Perhaps you can help me with one thing. It's been suggested, I think, that some of the views might be filtered. I mean, can you help me with this? And it may be that we need to look at the wireframes to consider the effect of filtration, if any. And the wireframes are, if I get it right, I hope I do, are core document C528, 5.28.
Yes, the reference to the views being filtered, Mr. Lier makes that reference in his paragraph 6.8. I don't think you need to turn it up, sir, but I'll just say what it says. It does say there, the residential development will be visible in part, but only with filtered views through boundary and framework planting. So what Mr. Lier is saying there is that you will only see the development in filtered views, either through existing vegetation or by the framework planting. I assume he means the planting indicated on the development framework plan, so the proposed planting. But if we turn to the first wireframe, which is from viewpoint 2, to really just briefly make the point that clearly in the image at the bottom of that page, which is on completion, so it hasn't allowed for the new planting. And clearly, if you turn over the page, the new planting would start to provide a degree of screening of the new houses, but certainly initially, there'd be no filtering at all of the new houses, and to my mind, that is a dramatic change in what is at the moment an attractive rural view, and it shows a large mass of new housing in the middle of that view, completely changing that view in what is at the moment an attractive approach to the village and a largely rural setting to the village. So initially at least there would be no filtering at all and the houses would be very clearly visible from that point.
Okay, thank you very much indeed. If we can return please to your summary, which we got as far as 8.3. So if you'd like to deal with 8.3, please.
The North Somerset Council Landscape Character Assessment, which has been adopted as supplementary planning guidance, shows the site within the northern part of the River Yeo Rolling Valley Farmland Landscape Character Area, which is Area J2. The stated landscape guidelines for this area include to conserve the rural pastoral character of the area, and the area of and around the site does indeed have a largely rural and pastoral character, despite the adjoining presence of the village to the northeast. As part of the preparation for the new local plan, the Council have also produced a landscape sensitivity assessment with the aim of assessing the sensitivity of the landscape around settlements where sites could potentially be allocated for residential development, to contribute to the site selection process, and also to provide a sound basis for the future determination of planning applications. The area of and around the site was determined in this assessment to be of high sensitivity.
Now, I just wanted to look, please, briefly anyway, at the Wardell Armstrong sensitivity assessment and what they say. And the reason I do that is because if I understand the position correctly, and tell me if I've got any of this wrong, is that initially at any rate, Mr. Lie didn't think that the land in question was of high sensitivity. It's his paragraph 6.4, which we can turn up if necessary. Help me first of all, if we can look at the map. What does that tell us about their Wardell Armstrong's assessment of the sensitivity of the land round this particular edge of Wrington?
Well, it shows clearly that the, well, it would be clearer if there's a key. I'm not sure if there's a key on the part of the map you got, sir, but the palest colour is high sensitivity. There's a medium purple, which is medium sensitivity, and a dark purple, which is low sensitivity, and there's a sort of beige colour, which represents allocated sites. So it clearly shows that the area of and around the site to the southwest of the village is of high sensitivity, and Mr. Lea has corrected what was an error in his brief and says that he now accepts that this assessment does show the area around the site as being of high sensitivity. But what I'd also point out whilst we're looking at the plan is that this isn't just a sort of blanket allocation of high sensitivity everywhere around the village or to the whole of a wider landscape character area. Wardell Armstrong have clearly thought about this, and they've looked at different parcels of land around the village, and they've allocated them different levels of sensitivity. And the level they've allocated for the area of the site is high.
Yes, I mean, before we look at their methodology, which I want to do, can we just look briefly at their assessment for Wrington? And I think, tell me if I've got this wrong, I was looking at paragraph 6.3.99, which is on page 52 of the document that has been copied. Should we be looking at that, or is there any other part of it which you think we should go to?
No, you've made the same mistake as Mr. Lea there.
Have I? Oh dear, well there you go.
That says to the south.
Yes, I'm Flattered, really.
That says to the south of the village.
I see, okay.
I mean, it is a bit confusing because the site is really to the southwest of the village, so it could sort of fall to either paragraph. But where it refers to the site is really paragraph 63100, where it says to the west of the village, the land is open, visually prominent, and located outside of the development form, and there are no landscape features which could potentially limit development sprawl. Owing to this, this land is of high sensitivity.
Can you remind, I didn't quite catch the reference there, excuse me.
63100.
63100, thank you. And just for the record, I think you wondering whether the plan had a legend or a key. Certainly the copy I've got has got a key and a legend.
I've got an extract from it, so the key isn't on
bottom
there.
right-hand corner, but just to reassure everybody, I can
Well,
see.
on this A3, whatever it is, A1 size copy, there's a key. Let's just look at the methodology, if we could, please, because that obviously can be relevant to the way that Wardell Armstrong have gone about their task. Rather than me make similar mistakes about the way they did it, perhaps you tell us which paragraphs we ought to be looking at.
Yes, and I think this is relevant because Wardell Armstrong clearly say, having carried out their assessment, that the site and surrounding area are of high sensitivity, and both the LVIA and Mr. Lee seek to depart from that and to disagree with the Wardell Armstrong assessment and say that when you look in more detail and taking into account things like the presence of the edge of the settlement, the sensitivity should be lower. But what I would say about that is, firstly, the point that clearly Wardell Armstrong did look at it in detail and they did consider some areas to be of lower sensitivity. But also specifically in their methodology, they do say in paragraph 5215, they do say that in determining the sensitivity, they looked at, there's a range of bullet points, but they include the third bullet point, the nature of adjacent settlement edges, the fourth bullet point, the settlement pattern, and then also in 5221, they say that conclusions with regard to sensitivity were combined judgments which took into account the following. And again, they say it includes things like topography, which is relevant to the site, visual prominence, which is relevant to the site, and the relationship with existing built form. So they clearly say in their methodology that they have taken into account the existing edge of the settlement. And also, it's just common sense in any case that if you're carrying out an assessment of parcels of land which, as the plan shows, are grouped around the edge of the settlement, they would clearly have been aware of the presence of the edge of the settlement. They couldn't have ignored it in making the assessment. So when they said that the landscape of and around the site is of high sensitivity, they were clearly aware that it adjoined the settlement boundary.
Okay, thank you very much. So if you then would go, please, to paragraph 8.4, in your summary, that is, and continue with that.
This would be a significant development of up to 61 new houses of up to 2 stories in height, extending out to the west and south of the existing edge of the settlement, across a locally prominent ridgeline, and introducing new built development onto a south-facing slope, which is prominent in the foreground and middle ground of views towards a Grade 1 listed village church from the southern approach to the village. The site is contained to the north and east by the edge of the settlement, though there is an intervening paddock to the east of the site, and also to some extent by the hedge alongside Half Yard further to the south. There is a trimmed hedgerow along the southern side of the area proposed for built development, but other than that, the site is poorly contained and open to view from the west and south, with the western site boundary unmarked on the ground and running across an open arable field.
2 points, if I may. You refer to the fact that there's poorly contained and open to views, from the west. Why do you particularly refer to that?
Well, it clearly has a bearing on the presence of the proposed development within the landscape. There is no containment there, and it's quite unusual, really, for new developments on greenfield sites to extend part of the way across a field and then stop. So it means that initially at least there'd be no existing containment and no apparent visual rationale for the development to extend to that point and no further. And new planting is proposed along that boundary, but clearly that planting would take some time to have any real screening or containment effect at all.
You refer, thank you, you refer to the intervening paddock to the east of the site. Is there any particular point you want to make about that?
Yes, it would be useful to look at the illustrative master plan, I think, for this. So the development basically wraps around the southwestern side of the settlement, but it doesn't adjoin the settlement boundary directly for all of its northeastern boundary. There is an intervening paddock which is excluded from the site and is part of the countryside, so there would be a little area of landlocked countryside between this development and the edge of the settlement. And if you look at the annotations in the key for the illustrative master plan, there are two small arrows leading from the vehicular accesses within the development. And what it says in the key for those arrows is tertiary connecting street, comma, delivery by others. And then sort of sketched into the paddock is an area of development. And what it says in the key for that one is just above the previous item. It says potential arrangement of development of adjacent land, delivery by others. So what I take from that is that while development of that paddock doesn't form part of the proposals, it is the assumption of the applicants that development of that paddock would take place in due course, and the proposed layout of the development would facilitate access into that land in due course. So if the assumption is that that site would be developed at some time, then that clearly has implications for how, for example, the views to the church might be maintained from the south, because some of the view corridors go across that land, and potentially if that land was to be developed, that could then interfere with the proposed view corridors.
Thank you. Okay, then 8.5, please, of your summary.
The proposed development would be visible and in many cases prominent from an area around the site which would be limited by the high ground of the Cleeve Ridge to the north, the edge of the village to the east, and vegetation within the gently undulating landscape to the south and west. There are also some more distant views from the higher ground of the AOMB to the south, but the development would not cause any significant change in those views. This area is relatively tightly drawn around the site to the east, but within much of that area the development would represent a readily visible and locally prominent incursion of built development into what is at present a largely rural and attractive area of countryside, which forms the setting to the village and affords attractive and distinctive views to the church from the south.
Yes, I mean, you refer there, of course, to the undeveloped nature of the surrounding countryside, the change to the views and so on. Do you want to say anything about the approach the LVIA takes to that particular issue and how they approach it?
Yes, the LVIA takes the view that the development is acceptable because it would be close to existing residential areas. And as I said just now, it also takes the view that that decreases the sensitivity of the landscape of the site. And while that is clearly relevant, and clearly the site is adjacent, although not directly for all of its boundary, it is adjacent to existing residential areas. That clearly is part of the existing landscape character and has an influence on the level of landscape effects. But to argue, as the LVIA seems to, that because the site is already influenced by the presence of adjacent residential areas, development would be okay, does seem to be something of a circular argument to me, because residential development is typically proposed on the edges of settlements. You wouldn't normally be proposing it out in the middle of the countryside. So if the presence of an existing settlement edge always reduced adverse effects and always made development acceptable, then development would always tend to be acceptable. But what the analysis in the LVIA, and I think Mr. Lie's evidence, omits is detailed consideration of the nature, the value and the sensitivity of the actual land which would be taken up. Not all land on the edges of settlements is the same, and I don't think it's enough just to say that it's close to the edge of the settlement, therefore it would be okay.
Yes, I mean, just so we've got the reference to the LVIA, we need to turn up the LVIA, which is core document C527, 5.27, and it's page 59 of the LVIA, and paragraph, I think, if I've got this right, I hope I have, 13.13.
Yes, it's 1313. It says in the middle of that paragraph, given that the character of the site is already influenced in part by the presence of the adjacent residential areas. And it goes on to conclude that because of that, the effects would be at a low level.
Okay, thank you. If then you can proceed with 8.6, please.
I have assessed the site and immediately surrounding area as of medium to high landscape quality and value and high sensitivity to development of the type proposed. As the landscape has a limited ability to accommodate change, and that change would take place within a presently open area, which is important to the character and setting of the village. There would be a medium to high degree of change to the local landscape as a result of the proposed development, because it would occupy a significant proportion of the presently open land at this point, and there would be a significant loss of that key characteristic, and of the presently open and attractive views across the site, including views to the church and to the wooded hills to the north. My assessment is that there would be moderate to high adverse effects on the character of the landscape of and around the site, because the development would be at variance with the pattern of the local landscape, would be locally visually intrusive, and would disrupt some important local views, which would remove the attractive landscape features of the open fields which make up the site, would introduce a significant scale of development to what is at the moment a largely peaceful pastoral landscape and could not be adequately mitigated.
Thank you. I mean, you said a great deal about the moderate to high adverse effects and the impact upon the appealed site. What view do you take about whether, in broad terms, this is an area where it would be appropriate to start developing a housing estate?
I don't think it would be an appropriate area to start looking at, really. I think because of those factors, because of the openness and attractive nature of the views, the fact that it's at the approach to the village from the south and the views of the church and the hills, all the points I've mentioned, really. And that, I think, is reinforced by the fact that the council did actually commission Wardell Armstrong to carry out an overall rational approach with a sort of degree of search to it as to which areas might be appropriate for residential development. And the areas which would be appropriate for development would be the ones of lower sensitivity, which they identified in their assessment. So they carried out a wide-ranging assessment in the case of Wrington of all of the land on the outskirts of the village, and any areas which they regarded as of high sensitivity would be, by definition, the last places you would start to consider as being appropriate for residential development. That was the purpose of the exercise they carried out.
Indeed. So, 8.9, please.
These adverse effects would be expected to decrease slowly with time as a proposed planting begins to mature. However, they would never disappear completely, and some long-term adverse effects, declining to moderate adverse after around 15 years, would be likely to persist as a result of the continuing presence of the new dwellings, which may become less visible over time in some views, but they would still be there and the open land would still have been lost. There would also be some significant adverse visual effects, mainly for residential properties adjoining the site and for users of the public rights-of-way in the area around the site and for people passing along Half-Yard Butts Batch. Turning to the second reason for refusal, this relates to harm to the local landscape and landscape setting of the village. And the main issues set out in the inspector's note of the Case Management Conference included the effect of the proposed development on the character and appearance of the area. My assessment is that there would be significant and long-term harm in all of those respects. Much of the rural character and landscape setting at this point would be significantly diminished and replaced by built development, and the development would obstruct many of the views to the church from the area around the site and significantly change the context of any which remain. In summary, I would therefore conclude that the second reason for refusal, insofar as it relates to my evidence, is fully justified and is in essence a simple statement of the effects and the resultant policy conflict which would result from the proposed development.
Thank you. I want your help, please, with some of the things, parts of the assessment of Mr. Lier himself in his proof of evidence. So you'll need his proof of evidence for this exercise. And would you go, please, first of all, I think, to Mr. Lier's paragraph 5.5. I'll find it myself. Yeah. In 5.5, Mr. Lier says, views towards All Saints Church and the Bracken Hills are maintained and framed within the site layout. And then he makes comments about existing views and so on. So what do you want to say about this, please?
I think it would be useful to turn up the view corridors parameter plan. Because what Mr. Lier says, he just says simply that views towards the church are maintained. And while some views would be maintained, you would still be able to see the church in some of these views. What Mr. Lier omits to say there, I think, is that the context and nature of the views would be changed significantly. And I did touch on that when we looked at some of the photographs earlier on. But on the view corridors drawing, and I do make these points, I think, in paragraphs 5.18 and 5.19 of my evidence, but I'll just summarize them briefly. And the points are that in view corridor 1, which is shown from Half-Yard looking to the north towards a church and is a similar viewpoint to some of the photographs we looked at earlier on, there is a view corridor there, but intruding into that view corridor from the left, there are some properties. The view corridor isn't drawn tightly to the edge of the properties, it sort of includes the properties, so any views towards the left of the corridor will be over the roofs of the new houses. To the right of the view corridor, just behind one of the proposed houses, there is a private garden to those houses. So there would be nothing, as far as I can see, to stop the people who occupy that property from planting trees in their rear garden. So over time, those trees could potentially get quite big, and they would also start to obstruct the view corridor. And further to the north in the view corridor, you can see on the aerial photographs some quite large trees which are in the background of the existing houses and already provide some obstruction. So if the new trees started to get to that size, there would be additional obstruction of the view closer to the viewpoint. And then finally on that one, there is also the view corridor itself is largely across the paddock, which we spoke about just now, which the applicant seem to assume will be developed in due course. So if that development takes place, then the view corridor, depending on the arrangement of the houses within that site, but if the site is to be developed, because the view corridor seems to occupy more or less 2/3 of it, it would seem to me that if it's developed in any meaningful way for housing, that view corridor would be lost, bearing in mind again that those houses would be on rising land, higher land than the viewpoint. The other view corridor 2, is intended to show that there would be some views towards the church from within the site. And the first point I'd make about that is that the view corridor is a bit misleading because it's not really aligned directly towards the church. The church is shown at the top of the page with a cross. The view corridor is not actually pointing towards it. But even so, within that view corridor, there is the edge of a house at the northeastern corner of the site. Just to the northeast of that, there is an existing property and another existing property on the opposite side of the road. And again, closer to the viewpoint, there are some landscape areas where planting is indicated. And if that planting gets to any height at all, really, bearing in mind the proximity of it to the viewpoint, that would also start to obscure the views. So even if there are some views from within the site to the church, I think they'd be significantly compromised, likely to be screened over time. And even if there are any views, they'd be views from within a housing estate. So the context would be quite different.
Okay, thank you. Could we look just at Mr. Liet's 5.10? Not sure that we need to look at all of this, but what do you want to say about the benefits, broadly speaking, the benefits that are being referred to in those paragraphs?
Yes, it's really a sort of list of why Mr. Liet thinks the development would be a good thing and is well designed and will produce a high quality landscape setting. I think he's referring to it in the context of the requirements of the NPPF, I think, at that point. But he's basically saying that he thinks that the development would add to the quality of the area and would produce a high quality landscape setting. The point I'd make really is that the site already provides a high quality landscape setting to the village. It's not in need of any improvement in terms of the landscape setting to the village because it provides the open foreground to views of the church and the hills beyond. And while the design may be perfectly acceptable in itself, and the council don't take any issues with the nature of the design of the development, it's really the presence of the development within the landscape in this location which causes the problems. So it's not really a design matter. And my view also, I say in my evidence, is that notwithstanding the fact that the development might include planting and new hedges and areas of biodiversity net gain, that wouldn't lead to any kind of net overall landscape benefit when considered together with the 61 new buildings.
Indeed. Thank you very much for that. Mr. Liet, I think in his 5.14, endorses the approach taken by the LVIA. I wonder if you can just help me with one or two matters about that. The LVIA, in their section, I think it's section, if we have to go back to the LVIA, it's section 10.11. Here it is. Section 10.11 of the LVIA, which is page 13 and
It is, yes, page 13.
13, thank you very much. Yeah, effects on the wider landscape and the character. Well, what do you want to say about that?
Well, it's really the point that the LVI has assessed effects for the whole of the River Yeo Rolling Valley farmland character area, which is what it says in 10.11, as minor adverse. Bearing in mind this is quite a large landscape character area. It's about 18 kilometres across from east to west. But then it also assesses in 10.14 the effects on the area around the site as also being minor adverse, and this is also set out in the summary table, which is the additional document which was provided this morning. So it seems odd to me that if you're assessing minor adverse effects on a very, very large area, and you then home in to the smaller area of and around the site, which is the correct thing to do, that the effects stay the same. If you're adding the same amount of change to a much wider area, in my view, it would be diluted by the sheer scale of the area. If you then focus in on a much smaller area, the effects should, in my view, be much greater, which is how I've assessed them for the smaller area of and around the site.
Yes. Now, yes, is there any other point you would like to make about the LVIA or any other particular comments you have upon Mr. Liet's evidence that will be helpful to the inspector?
Well, really just the point that Mr. Liet doesn't really set out anywhere what he thinks the effects would be. He just adopts the conclusions in the LVIA, which, as I've said, I think are strange because they assess the same effects even at the different scales. And also, there is, to my mind, some confusion about the longer-term effects in year 15, because if we look at the summary table, the summary table says...
Sorry, the summary table we were given this morning?
Yes, sorry, yes,
sorry,
yes,
yes.
the summary table there. In the right-hand column, it's got the year 15 landscape effects, and for the LVIA, which is shown as the LP assessment, the LP LVIA. So, second row down, it's the middle line, which is their assessment of landscape effects, and it says that they'll be minor beneficial by year 15. But, as we just looked at, the LVIA, on its page 13 in section 1015, says that the minor adverse effects upon the landscape character and features of the site remain. So it seems to me, and I don't fully understand it, that the LVIA is saying that there'll be long-term minor adverse effects, but the summary table seems to be saying that there'll be minor beneficial. So which is correct from their point of view, I'm not sure. But the LVIA definitely states in 1015 that the minor adverse effects upon the landscape character and features of the site remain.
Thank you very much indeed. Is there anything else from your point of view?
No, I don't think so.
Thank you very much indeed. Will you stay there, please?
No, I've got nothing yet. Well, that might change. So can we have cross-examination, please, Mr. Boyle?
So I'm going to ask for section 4 of this Wardell-Armstrong document to be circulated as well. It's the section entitled Guidance. Mr. Etchells, do you have the whole document? I'm not taking you by surprise, am I?
Sorry, I've looked at the whole document, but I don't have it all with me. I have extracts from it, which don't include section 4.
You have section 4 now. Do you want to just cast an eye over it before I get going, and then you'll have had a chance to see it?
Please take as much time as you need.
So when would you be looking to break for lunch, do you think?
That's a good question. I was just wondering whether, bearing in mind we're giving Mr. Etchell an opportunity to look at this, perhaps it's an opportune moment now, actually, to
Well,
break for
I'm
lunch.
happy to either get going and break as appropriate, or to break now and come back cleanly after lunch. Entirely up to you, sir.
Can you remind me what your estimate was? About an hour and a half, was it?
That's sort of all day.
Yeah. Well, perhaps we should break for lunch, unless you're keen to, because...
Well, I was going to say, sir, if Mr. Etchells has got to look at this document, I mean, it's a matter for him entirely, but I would have thought
Yeah, I think
a
it's
break now
just-
it would not be a...
Yeah, it's just an easier way of making use of time, apart from anything else. And it
Well, so
keeps
just
things
in the
compartmentalised.
few minutes before 12:30, can I just give you the documents that we'll need when we come
That's
back?
be very helpful, please.
So I think you've already got the two witnesses' proofs,
Yeah.
the LVAA, the wire frames, and now you've got further extracts of all the Armstrong documents. You will also need the core strategy, which is, let me get the reference, CDA1, and the development management policy, which is CDA2. Mr. Marsh's rebuttal proof, the comparator sheets, the blue sheets, and the appeal decision Rectory Farm, which I think is Rectory Farm is CDJ22, so. And then the MPPF, which I don't think is a CD, but I'm sure everybody has access to it.
Well, I'll certainly be able to find my copy.
Yeah.
Thank you.
I think those should be the documents we need.
That's helpful. Thank you very much. I think it is, I mean, for future reference, it is really handy to be forewarned about what documents one is going to be taken to. It just makes it easier to find them. So if I don't expect them in days in advance, but I don't know, half an hour or so, that's always handy. And if you're in any doubt, you can always send them over to the case officer, Keir Brown in Bristol, and he'll send them the list on to me. That is helpful. I think we will take the lunch break now. My clock is saying it's very nearly past. Is everybody happy if we break for around just over 50 minutes? If we were to resume at 10 to, would that give everybody enough time?
So can I, forgive me, just to ask for the whole hour, we will eat in the little cafe across the road,
Okay.
and
Yeah.
I'm not entirely certain how speedy they are given the lunchtime rush.
No,
so
and
sorry.
there's getting there as well. That's fair comment. So we'll call it an hour, and now I've lost my timer. So yeah, everybody content with what would that make it? 1:30. Yeah. Okay. We'll adjourn there and resume with cross-examination at 1:30. Thank you.